take doing by state or by private, yeah, by person. So any question for the first presentation, please, for attendance. This issue can review from international humanitarian law. Yeah.
Yes.
Yeah.
That's one of the development actually from international humanitarian law. When then technology becomes a parties, becomes one of the tools to do the crime.
Maybe any question, or I have question if to that question, yeah. Okay. I think how about that? About the actors, if it is doing by state or by person, if it is characteristic as international crime.
Yeah. Okay. Okay. Thank you so much, Bu Aryoni, for the question, of course, and then all respected presenters in this room. Yeah, thank you so much for the question. Basically, both state or person related to how to use technology as a tools for doing a crime. In terms of the technology, one of the obstacles actually, as my colleague has explained to all of you, they're talking about borderless in one thing, and then the second things, the anonymous matters. In both of them, actually, it's quite difficult for the international law itself right now to cover whether the actor should be sentenced and so on, because as we know that some international law or some international convention basically do not govern technology as a tools, because some of them, as we know, that's coming from in the past, and they just recognize some tools, traditional tools, no modern tools as the technology right now. So this has become the most important things that we will face in the future, especially regarding to the some crimes who use technology as the tool, as our paper actually. I think that's all.
Maybe from other participant, any question? Okay. Once again, Mr. Maskun, is there a legal instrument for this?
Yeah. Yeah, basically we try to because the focus of this research actually coming from the issue about the crimes of aggression. As we know, even in the Statute of Rome actually doesn't explain clearly about the what the definition of aggression, and that's theoretically, of course, but in practically we saw that some countries doing the aggression, they act aggression, and then they use technology as a tool, as my colleagues explained. In some cases, Estonia case in Stunet and Dunplan case, and it's quite difficult. It's quite difficult when we try to to judge whether the state or we can prove it the state whether they do the aggression or not, because we don't have any. What I mean, we don't agree for one definition one aggression means related to technology, and this has become one big problem actually when we try to when we try to make it link between aggression and then aggression in one as the one of the oldest international crime, and then technology itself as the new one, as the modern technology itself, and also according to us how both aggression and then crimes of the technology as the tool of crime used by some actors, either they are states or either they are state or a person or probably also the companies. That's it. Thank you.
Yes. Okay. Thank you. Thank you for share ideas. And insightful. Okay. For the second presentation, Ibu Rohaida is join in this room.
Yes, I am.
Oh, okay. Assalamualaikum.
Waalaikumsalam warahmatullahi wabarakatuh.
Yeah. Please, Bu Rohaida, can present for and discussion 10 minutes.
Okay, insyaAllah. Okay. Bismillahirrahmanirrahim. Assalamualaikum, salam sore, good afternoon. Distinguished speakers, presenters, ladies and gentlemen. My presentation today, I will divide it into 4 parts. Yeah. First, I will describe what is the implementation gap. Slide number 2, please. And I'll be looking at some of the example of the implementation gap in Malaysia. And I'll identify causes of the implementation gap in Malaysia. And finally, I'll conclude with some suggestion as a way forward. Yeah. So before I proceed, I would like to stress that the context of today's presentation is human rights in Malaysia. Okay, moving on to the first part. Yeah, what is implementation gap? In this research, I divided into 2 specific contexts. First is with regard to international and domestic context. Yeah. And as we know that after state has become a party to international treaty or customary international law has been established, so the issue of implementation of international law, they become equally important. Yeah. So state has to adopt formal legislation or regulation, yeah, to comply to those treaties that have been ratified. While in Malaysia, there's no guarantee that Malaysian law will be compatible with the pertinent norm of international law. Why is it? This is because the conduct of state body in Malaysia, specifically court and also legislative body, the way they behave determined by domestic law rather than international treaties that they have ratified. And because of this, the first context of the implementation gap occurred. And the second one is, I call it as domestic legal and practice context. Yeah, and this gap exists when there's a vacuum between existing legislation and the administrative, economic, legal, and political practices. And this gap can be in form or in substance. And this gap lead to violation of human rights. And obviously, it needs to be closed to ensure protection of human rights in Malaysia to be safeguarded. Now, in 2007, the Special Rapporteur, Stephen Hagen, commented that to ensure progressive development of international human rights law require meeting 2 elements. First is the adoption of new legal norms, and second, creation of modern institutional framework. However, he added that in many parts of the world, there still exists implementation gap. And this implementation gap is between the norm and the practices, the formal recognition and the actual situation of the people. And ladies and gentlemen, moving on to the second part of my presentation, what are some of the examples of this implementation gap. Okay, the first example you can see in the next slide, slide number 6, please. Yeah, in the context of disability right. Yeah, and in 1988, there's a policy that being introduced by Malaysian government and mentioned in the Malaysian Civil Service Circular number 10 of 1988, and after 20 years, it was refined and enforced in April 2008. And what is this policy, and what is this policy relation to the disability rights? This policy allocated a quota of 1% of the total workforce of the government sector for the people with disability, right? However, in reality, because that has been enforced in 2008, and in 2013, the reality shows that through the statistic, only 1,745 person with disability were employed by the government out of approximately 1.4 million of government servants. That is just equivalent to 0.12% and not achieving the 1% as targeted by the policy. Now, moving on to the second example in the health policy. I mean, recently Malaysia has introduced a very good, wonderful health policy vis-a-vis My Salam and Perker B40. Next slide, please. Yeah, which provide for insurance coverage for those individual earning below than 4.36 thousand, meaning that 4,360 ringgit Malaysia per month. Yeah, it is a good policy. But what happened in this case is that the implementation as a process of translating the policy into action to achieve the goal of the objective has failed. Because there's no coordination among the enforcer of the policy, and it resulted in a failure to meet the target to benefit the beneficiaries. Yeah, and finally, the last example of implementation gap, I reflect it in slide number 8. Yeah, in the context of the indigenous right, as you can see in the slide, through the 5 cases, the judiciary has made legal recognition on the rights of indigenous people to their customary land. And what does it mean? It means that, even the positive law, the law in Malaysia has not recognized their right, but the common law principle is adopted, and because of that, they entitled for adequate compensation if their land were to be acquired by the state. And this entitlement will go beyond their settlement, meaning that, even the area in which they run their activities, and not necessarily the area where they settle or where they live. But despite of this positive ruling, these state agencies, I'm talking about land office, in practice, in dealing with land acquisition of customary land of the indigenous people, they behave or they act in contradict to the rights that has been recognized by those court, including the Court of Appeal and the APEC Court of Malaysia. Now, the slide 9 until 11, I listed down some of the reservation entered by Malaysia, on CRC, Convention Rights of the Child, and CEDAW, Elimination of Discrimination Against Women Convention. And upon examining the reservation, arguably the reservation are incompatible with the object and the purpose of the treaty. And let's jump to slide number 13. And because of that, Malaysia, when Malaysia had its third cycle of during its UPR Universal Periodic Review Assessment in 2018, Malaysia received a lot of recommendation by a state to withdraw its reservation because obviously CEDAW, CRC and CRPD, they are instrumental to the protection of human rights in Malaysia. And also Malaysia received quite a number of suggestions to adopt measures in ensuring increase of efficiency and accountability of public servants. Next, moving on to the third part of my presentation, ladies and gentlemen, on the identification of the causes of this implementation gap. I have given you some of the example. In this part, I submit that full implementation of the legislative and administrative advances in Malaysia faces many obstacles and problems. The four variables create an implementation gap. What are they? They are lack of accountability on the part of the state, lack of legal legitimacy, lack of political will, and lack of capacity building and resources. And I relate this submission to the next slide, to the concept of domestication of human rights in Malaysia. What does it mean? It means that the enjoyment of the rights of the people in Malaysia is determined by the domestic law and not necessarily by the international treaties that has been ratified by the state of Malaysia. So additionally, the ability of Malaysian state to discharge its responsibility in the area of human rights effectively depends on the strength of its domestic institution. So it depends on the law in Malaysia, and it depends on the way, the strength, the weaknesses of the domestic institution. As reflected in slide number 8, it's demonstrate that despite of judicial recognition on the rights of the indigenous people to their land, there still exists an implementation gap between the legislation and day-to-day reality in Malaysia. So what are the four variables? You can see in the next slide, the accountability is the most important variable. According to Colin Scott, accountability, moving on to the next slide, please. According to Colin Scott, accountability is an ability to give account for one's action to some other person and body. And I am submitting that this variable is the level is very low in Malaysia. That's why there's a lot of allegation of corruption among the government servant and establishment of state elites within the government servant. And secondly, the law that has been enacted in Malaysia has lack of legitimacy. And a legitimate law are rules and law that derive from participation and consultation, from public in general as well as the specific group in the lawmaking process. But unfortunately, the consultation and the participation is not made compulsory in Malaysia, and therefore arguably the law that being enacted by the parliament are illegitimate law in which can be rejected by the people during the enforcement. Okay, finally, next, political will, because I submit that there's a lack of political will on the part of the government, and juries hopes submit that no assurance that political actors will arrive at appropriate definition of order except through political will backed by force. And the political will as a concept is a demonstrated credible intention of political actors to promote human rights at a systematic level. And I include in the paper, in the full paper in my book, some of the examples to demonstrate there's a lack of political will on the part of the state. And finally, ladies and gentlemen, the fourth part here, how do we eliminate this gap? We have to eliminate this gap, otherwise, the violation of human rights continues. I propose all the three branches of the government to play their role. Firstly, the legislative body, they are the traditional lawmaking body, so they have to prioritize the legislation that has human rights component in it, and get it deliberated and pass it. And secondly, the judiciary, they must adopt a more liberal interpretation for the legal provisions so that the protection of human rights in Malaysia can be maximized. And finally, the state executive, they have to show their commitment, they have to show improvement in the structure of the institution and the institutional processes, and most importantly, in doing so, they have to work closely with the stakeholders. And finally, Suhakam, as the national human rights institution in Malaysia, they also can play a role in bridging the gap. How? Through relevant recommendation to state, especially with regard to implementation of international human rights law standard in Malaysia. With that, I thank everyone for the attention.
Thank you for Bu Raheda from University Kebangsaan Malaysia. The presentation about implementation gap of international law within the Malaysian legal framework, and she gave example in the field indigenous right, CRC, disability right, etc. Okay, for participant, maybe any question? Is there any question?
Dr. Haida, I have a question.
Okay. Please, Pak Azmi. Yeah.
Azmi from your neighbor Usim. You are Dr. Haida. I do not know whether or not my question is related to the topic that you have delivered, but it got something to do with orang asli, because you were talking about the protection of our indigenous people. So since independence and up till now, do you think that the government has done enough to protect the rights of indigenous people in Malaysia, particularly the orang asli? Thank you.
Okay. All right. Thank you, Dr. Hazim. Hi, neighbors. Okay. I mean, the question is like, has done enough? Of course, it's not enough, because when we look at the even the decision made by the court when it gives the recognition to the rights of indigenous people, and they are still not compatible to the international law standard. So if we use the international law standard vis-a-vis the UN DRIP, the specific declaration on the rights of indigenous people, no, not yet. Malaysia has not done enough. I mean, the main standard that is lacking in the Malaysian context is a principle which is called FPIC, free, prior and informed consent, in which it put an obligation to the state to get permission before moving or before acquiring the indigenous people's land. That has not been recognized in the Malaysian context, and also there's a concept which is called self-determination, also has not been fully recognized by Malaysian judiciary as well as the Malaysian executive in their policy. But Dr. Hazim, I have to say that there's improvement, there's an evolution, there's a progress in giving what the indigenous people deserve of, in recognizing their right. Yeah. So it evolved slowly but steadily. Yeah. But we hope that I do not know where. I mean, this is the role of the human rights advocate to actually put the political will to pressure the state to do the to bridge the gap. Yeah, when it comes to ensuring our indigenous law is compatible to the international standard. I think that's all.
Yes. Yes. Thank you.
Thank you for the question.
Okay. For the next, for the next presenter, for the third, Mr. Hasan Suryono
Okay.
is joined.
Please have the committee show my PPT. Please have the committee show my PPT.
We don't receive your PPT, Pak Hasan, so you can present without PPT. Yeah.
Yes.
I'm sorry, Ibu. I am second speaker. Can I help to share the material of the PPT?
No, in the rules, we have asked from the presenter that not send PPT to committee. So please present without PPT. Yes.
Okay. I'm sorry. We have sent today.
Yeah. Please present without PPT, Pak Hasan. Okay.
Okay. Assalamualaikum warahmatullahi wabarakatuh. Best wishes for all of us. Yeah. The Honorables Mr. Dr. Aryuni Yulianing Tingse, Baccalaureate of Law, Master of Law, and the moderator. The happy presenter, as well in the ladies and gentlemen of the session and brother who were present in this room. On this question, I introduce myself. My name is Hasan Suryono, and my team, Brother Raharjo, who came from 11 Maret University, Surakarta. Today, Tuesday, 3 November 2020, along with the team will present a paper entitled The Effect of Globalization on the National Legal Policies of Human Rights. The purpose of writing this paper is firstly to explain whether human rights 1945 Constitution of the Republic of Indonesia have adopted universal human rights. Secondly, what is the configuration of the implementation of universal human rights in the Republic of Indonesia? The Republic Indonesia, the result of the study will submit the theme. Result and the question that human rights in the Indonesian constitutional have present facility adopted universal human right value to the aspect. This ado different of their level and implementation because the theoretic level concern the substance of human right will implementation represent the culture in which this human right will apply. So it's not the human right that will please the social system and the society, but the process and implementation initial that will replace human right must be in accordance with the value of Pancasila and must be based on Pancasila. 2. Variant international human rights instruments that have been adopted in the state of the Republic Indonesia into the regulation and implementation must be in accordance to condition of the Indonesia people. But now it depends on the political will of government of the Republic Indonesia to implement fully and accurately the above Constitution. Conclusion: human rights, the Indonesia Constitution are responsibility in adopting universal human right value because the theoretical level concern the and with the human right will be applied, so it's not the substance of human right. The will place human right must be in accordance with the value of Pancasila and must be cautious. Various international human rights instruments that have been at the Republic Indonesia in possession. Geneva Agustus 12 1949, Law Number 15 of States, Convention of the Elimination of Discrimination Against Women, President of the Place, Convention on the Right of the Child, Presidential Decree number 504, Convention of the Prohibition of the Development, Stopping of the Process before of the contraction, President Decree number 1, International Convention against Sport, Law number 45. Basing on the Dr. Johannes, thank you very much. Yeah. Thank you very much. For the response of this paper, and I will plan as follows. Thank you.
Okay, thank you, Mr. Hassan. It has presented about the effect of globalization on the national legal policies of human rights. Okay. Please, if any question for Mr. Hassan from participant?
May I ask question to Dr. Aryuni, please?
Yeah. Yes,
Okay.
please. Pak Mas.
Thank you so much. Yeah, thank you so much, Bu Aryuni, and Pak Hassan and team. I would like just to know your opinion about business as a part of globalization and its connection or its relation to the human rights. Because in somehow right now in Indonesia, we try to develop business and human rights as one new
Business.
as one actually. So that so what do you think or your opinion about business and human rights as the new one to connect globalization in one thing, and on the other hand human rights in another. Thank you.
Okay. Mr. Hassan, if any
For this
difficult-
reason,
Okay.
Raharjo, for this reason, Raharjo is welcome to present the result of the study. Thank you,
Yes.
Raharjo, for your generosity.
Okay. Ibu Aryuni and Bapak, I don't know if it's one P1. Thank you for the question. I think this is very interesting. We do have to ask for very sorry because we have sent the presentation is today. Uh, Forgive us because we don't read the deadline about the presentation. Right, about the question about what your opinion about business on human rights. We know that human rights is very interesting, and in Indonesia, we know that we have many problems of human rights is incomplete. I mean, is unfinished. So there is maybe my opinion about business on human rights is it's just like we know that human rights is very good, but sometimes we have an opinion about if there is a regulation about our government about the human right, maybe something is not good, but we have Pancasila for our ideology, and in this paper, our explain about the effect of the globalization of the about human right legislation, and we know that the normative is good. The normative is very, I think, about the constitution, about human right, about rights to life, rights to make a family, and so on. It's very good, but sometimes in business, we know that if you you're a question about what about the business, because if the business about maybe environment, we know that sometimes there is problem. If you think a business about some maybe about economy or we call a perdagangan, sometimes also there is problem on human right and others. So I think our opinion is clear about the normative is good, but sometimes the implementation is not good. It's like the explains before this about human rights in Malaysia, about indigenous people in Malaysia. It's good from the normative, from the law, but sometimes in the implementation is not good. It is same our opinion about the business on human rights. Thank you.
Two more or less, please forgive for me my limited ability in this matter.
Okay, thank you, Mr. Hassan, for the presentation. Yes. For the next presenter, for Pak Hasmi, please.
Yes, I'm ready.
For present, yes.
Okay. So do I have to upload my own slide, or you will be doing it for me? All right.
We have ready.
Okay, Assalamualaikum warahmatullahi taala wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you very much, Usud, for accepting my paper for ICOLGAS. I'm Muhammad Hazmi from Kuala Lumpur, Malaysia, and I'm now an associate professor at the Faculty of Sharia and Law, University Sains Islam Malaysia. And this article of mine is entitled "The Invalidity of Penang Treaty," because we were colonized by the British back then, and the British, when they arrived in the Malay lands, when they arrived in the Malay Peninsula, before they wanted to take certain lands, they would enter a treaty with the local kingdom. Like for kerajaan-kerajaan di Indonesia pun sama juga. So we also have kerajaan-kerajaan di Malaya. So now I would like to bring you into the path of history to show whether or not what the British did to us was valid under international law or otherwise. Okay, we move on to the next slide, please. Okay, this is the outline of the presentation. Can you please click, because my slide has a lot of animation, so I need your kind assistant, Mr. Jonathan, to click on to continue clicking. Okay, right. Can we move on to the next slide? Right. Okay, this is a map of Peninsular Malaysia. All right. As you all know, in Malaysia right now we have third wave of COVID. So we have like a conditional movement control order or partial lockdown in Selangor, Kuala Lumpur, Putrajaya, and in a province in Nilai. So basically, we cannot go anywhere at the moment. We can go to buy food, but just that. So pray for us. Our conditional movement control order will end in the next 10 days, inshallah. Okay, now I'm not talking about Selangor. I'm talking about a state called Pulau Pinang or Penang. Can we move on to the next slide? Okay, this is where Penang is located. 4 hours away driving from KL with the Plus Expressway, and just 50 minutes flight from Kuala Lumpur International Airport. I really miss flying because ever since COVID, I'm not able to fly anymore, and the last time I flew was to Palembang in 1st March. And when I got back to Malaysia, 15 days after that, it was COVID all around us. We could no longer fly. So hopefully COVID will go away soon. So I'm now talking about this state called Pulau Pinang. Can we move on to the other slide? Okay, Pulau Pinang is part of the old kingdom of Lanka Suka in the past, in the 3rd century AD. Okay, can you please click, Mr. Jonathan? Okay, and this is all historical kingdoms in the past before the whole territory were under rule of Kingdom of Sriwijaya. Can you please click some more? Okay. So this is the old pelabuhan, the port of Kedah, and that one on the top is what we call as Bujang Valley Archaeological Site, the old Hindu temple in Kedah, just like what you have in Borobudur, which is a Buddhist temple. In Kedah, we have Hindu. Before we converted to Islam, the people in this region were largely Hindu and Buddhist. They embraced Hindu and Buddhist religion. Can we move on to the next slide? Okay, so this is part of the Pulau Pinang, Kedah, and all these kingdoms were part of the larger Malay archipelago. And move on to the next slide, please. Okay, and Kedah, Pulau Pinang, the Malay Peninsula was once used to be part of the Kingdom of Sriwijaya. And after that, Majapahit. Mr. Jonathan, can you please click the slide for me? Can you please click some more? Okay, click some more. Right. Okay, and then the Malacca Sultanate. After Sriwijaya, Majapahit, and then came the Malacca Sultanate. And the Malacca Sultanate was once Kedah and Pulau Pinang was put under the rule of the Malacca Sultanate. And Malacca Sultanate was finally colonized by the Portuguese in 1511. Nevertheless, Portuguese only colonized Malacca. They did not colonize Kedah and Penang. Kedah and Penang were still largely independent. Can you please move on to the next slide? Okay, so the Kedah Sultanate, which used to rule over Penang before Penang was taken by the British, the Kedah Sultanate was the one who has sovereign over Penang. Orang Indonesia bilang Penang, Penang. Bilang Pulau Pinang. Tapi kalau orang putih, orang bule itu dia bilang Penang. Jadi ada sebutannya Pulau Pinang, ada yang Penang, ada yang Penang. Sebutan aslinya Penang, Pulau Pinang. Gitu. Jadi Penang. Kedah Sultanate that ruled over Penang was established in 1136 AD, much older than the Sultanate of Malacca. Alright, and Kedah used to rule over some parts of southern Thailand and the island of Pulau Pinang, or internationally it's known as Penang. Move on to the next slide, please, Mr. Jonathan. Thank you. And this is the territory of the old kingdom of Kedah. Kedah exists since 1136 AD, and Sultan Kedah has its keturunan until today. So it's one of the longest ruling dynasties in the world. And Kedah right now is one of the kerajaan in Malaysia. Okay, we move on to the next slide. Right. In the past, Kedah and Siam had a very good relationship. Kedah and Siam, Thailand. In the past, Thailand was known as Siam. But as Siam got stronger, it wanted to put Kedah under its power. So what happened? Siam wanted Kedah to send bunga mas, a tribute, ufti, a tribute, in the form of a golden tree to Siam every year as a form of tribute, as a form of showing to Siam that Kedah depends on Siam. So Kedah sends this bunga emas every year. However, Kedah looked at this as a form of friendship. You know, in diplomatic relations, one nation provides gift to another nation, and in return, the other nation would return the favor. We still do it until today. Can we move to the next slide? Okay. Can we move to the next slide, please? Right. And as time passes by, Kedah became weaker and Siam became stronger. So Kedah had no place to go, and Kedah Sultan of Kedah heard that the British were sailing through its waters, and it asked for the assistance of Francis Light, the guy in the picture on the left, that we should sign a treaty. In that treaty, the British should protect Kedah, and in return, Kedah would lease, menyewakan, mengkontrakkan the island of Pulau Pinang to the British. So that was the original agreement in 1786. Sultan Kedah would lease the island of Penang to the British, and the British would provide protection to Kedah, all right, from Siam. Okay, so Penang was ceded by the Sultan of Kedah to the British in 1786. That's why now Pulau Pinang and Kedah are different provinces in Malaysia, even though originally Penang and Kedah was part of the same province. Can we click on to the next slide? Okay, so nevertheless, when that happened, when the treaty was signed, Siam came and attacked Kedah, and British did not help at all. Can we move to the next slide? Okay, so the treaty was never honoured as the English India Company refused to protect Kedah from subsequent attacks by the Siamese. And the Sultan of Kedah wanted to take island of Penang back, but because British was so strong, he failed to do so. And as a result, not only the island had to be ceded to the British, part of the mainland, the province Wellesley, was also ceded by the Sultan of Kedah to the British with the honorarium of 16,000 Spanish dollars, and this is still being paid by the Penang state government to Sultan of Kedah, 18,000 ringgit every year to honor this treaty. So, moving on to the next slide. Okay, now the question, I have two arguments. Okay, the Siam regarded Kedah as its vassal state, negeri bawahan. Siam menganggap Kedah negeri bawahan Siam. So as a negeri bawahan, as a vassal state under international law, a vassal state cannot enter into international agreement with the British, right? So in a way, the treaty of Sultan of Kedah with the British giving island of Penang to the British is void. We can say that. That is argument number one. Now let's go to argument number two. Okay, let's say if Sultan of Kedah really is the sovereign over the island of Penang, will this treaty still be valid? We look at the treaty, Article 26 of the Vienna Convention of the Law of Treaties, which is a customary international law for law of treaties. It states that treaties are to be upheld in good faith. Treaties are to be upheld in good faith. But we, as we have seen earlier, Francis Light, the British, did not honor the treaty that it has signed with the Sultan of Kedah, making the treaty voidable. So in conclusion, can we move on to the next slide? Okay, so Francis Light never honored the treaty and basically the British exercised duress and undue influence to compel the helpless Sultan to give in. All right, so basically the treaty should be considered voidable. So, and in conclusion, okay, this is the real conclusion now. Move on to the next slide, please. Okay, under such circumstances, was the cession valid? adakah penyerahan Pulau Pinang daripada Kedah ke British sesuatu yang sah? Was the cession of Penang to the British valid? Okay, in my own opinion, whether or not the cession was valid, the British has governed Penang for 171 years, indicating effective occupation over this territory. Penang was largely recognized by the international community as a former British colony, and this is recognized through this UNESCO World Heritage Site as a former British colony. And Penang only gained independence within the Federation of Malaya in 1957. However, putting the element of effective occupation aside, it is not too simplistic to state that the validity of the Treaty of Cession by the Sultan of Kedah to lease Penang to the British is questionable, because number one, it is not done in good faith, and number two, the Sultan of Kedah was made to sign the agreement under duress or undue influence. So the treaty in a way can be seen as questionable both from legal and historical point of view. So with that, I would like to thank you for your kind time for listening to my presentation, and if you have any question, I would be happy to address them. Thank you very much. Terima kasih, matur nuwun.
Thank you, Pak Hasbi. Any question for participant about invalidity of Penang Treaty? So we know about the history about Kedah, Siam, tadi Pulau
Penang.
Penang. Well, okay, I have the question, Pak Azmi. So what the legal effect if the Penang Treaty is invalidity?
Okay.
For your opinion, yeah.
If let's say the Penang Treaty is regarded as invalidated, so I guess Penang should be returned to Kedah. Penang should be returned to the original state Kedah, because both are in Malaysia, so it doesn't matter if the state is being returned to its mother state. However, we have to look, this is, then again, it will become a political issue, because Penang is a Chinese majority state and Kedah is a Malay majority state. Would this state then merge? So that's number one, the political question. And number two, in terms of the will of the people, would Kedah accept Penang as part of its state, and would the people of Penang want to be part of Kedah? That's another thing. And number three, in order for that to happen, the Penang state government would have to agree to join Kedah. Without the agreement of the state legislative assembly of the Penang government, then this would not happen. So in my opinion, whether or not it's invalid or otherwise, Penang has been governed by the British for centuries, for 171 years. I believe that the treaty was invalid, and the British has been very cunning in this way to take Penang away from the Sultan of Kedah. Okay, nevertheless, we have gained independence. The best way for us right now is to regard the treaty as invalid and move forward, and to build a better nation, so that we will never be cheated anymore by former colonial powers, by any powers for that matter. Thank you very much.
How about the status now?
The status now, Ibu Aryuni, there have been calls, ada seruan, there have been calls for Penang to be returned back to Kedah, but I don't think that's going to happen in a near future, because of number one, political factor, and number two, it depends on the people itself. If the people doesn't want to merge, then nothing would happen. And because both are still in Malaysia anyway, so it doesn't matter.
Okay. Thank you, Pak Asfi.
Thank you.
Yes.
Matur nuwun, Bu.
Matur nuwun. For the next, myself will present about law enforcement in exclusive economic zones. Problem in the implementation of Article 73 UNCLOS 1982 in Indonesia. Yeah. Yeah. Next. Good. Next one. Yeah. Indonesia has ratified UNCLOS with the law number 17 of 1985, and law enforcement in EEZ is regulated in Article 73, verse 3, that state penalties for violation of fisheries law and regulation in EEZ may not include imprisonment. It has adopted in fisheries law in Indonesia. Okay, next. But in implementation, there are two judgments in Supreme Court. One, first, the judge only imposed the sentence fine because Indonesia has ratified UNCLOS, and second, the judge can sentence imprisonment as a substitute for fine. So there's problems. How is the ideal model of the implementation of the Article 73 UNCLOS in Indonesia? This specification of research is normative juridical that use secondary data, and the approaches for the research are statute and case approach. Okay. The implementation in Indonesia, there are 19 judgments at the appeal to Supreme Court since 2015. 12 sentencing, the fine, imposed fine, and 7 sentencing imprisonment as substitute for fine. Jadi ada denda dan pengganti denda. For the problem implementation this article, many perpetrators cannot pay the fine, and the perpetrator not impose the sanction, so there is become issue in Indonesia, and not give deterrent effect. Next. If review by Gustav Redwood theory, we can view from philosophical aspect, legal certainty aspect, and sociological aspect. For philosophical aspect, there is unfair is the term of condemnations against Indonesian citizens and foreigners committing the fine. From legal certainty aspect, there is Article 30 of Penal Code is the solution to the defendant that incapable an object to pay, so they can impose for imprisonment. In sociological aspect, if a crime committed by the foreigners is sentenced with fine only, and the ineffectiveness of law enforcement will occur in the term of fisheries crime, cautioning the sentencing of fine not allowed by alternative punishment substitute for fine. So I have the opinion for conclusion based on the theory of Gustav Redwood, the judge can impose the penalty in lieu of fines for illegal fishing perpetrators in Indonesian's economic exclusive zones. Okay, this is my presentation about the issue. Maybe any question?
Dari Pak Hasan, Bu. Pak Hasan mau tanya, Bu.
Yes, please, Mr. Hasan.
Mrs. Dr. Aryuni Yuliansih Bachelor of Law, Master of Law. Please explain what factor influence the implementation of Article 73 earlier. What is the solution to overcome it? Please explain what factor influence the implementation of Article 73 earlier study. What is the solution to overcome it?
Faktor apa Pak Hasan?
Faktor yang mempengaruhi maksud saya ya. Faktor yang mempengaruhi pelaksanaan pasal 73 itu adalah bagaimana solusi untuk mengatasinya ya, Bu. Di sini what is solution to overcome it?
Okay. There is two different judgment ya Pak ya, from Supreme Court. There is two decision. One is Indonesia must comply UNCLOS Article 73. If Indonesia must comply, so for perpetrator illegal illegal fishing do not atau prohibited impose, dilarang menjatuhkan hukuman badan, dilarang menjatuhkan hukuman badan or prohibited imprisonment. And the other judgments, there is alternative. The judgment is can impose fine to substitute imprisonment for substitute fine, hukuman pengganti denda. In fact, if we fully comply UNCLOS, many perpetrators that cannot pay the fine, many perpetrators that tidak dapat membayar denda, cannot pay the fine and tidak dapat dihukum and don't imprisonment. So there are not have deterrent effect, tidak menimbulkan efek jerah, not have deterrent effects. So there is alternative. The judge can impose the imprisonment as substituted for fine. Begitu Pak Hasan, is the answer.
Thank you for the explanation. But if the fine is not fine, then how do you process? But if the fine is not fine, then how do you process? Maksud saya, jika denda tidak dibayar, lalu bagaimana tindak lanjutnya, itu maksud saya. Itu penjelasan.
Yes. For the solving this problems, this is menjadi, mungkin bisa di ini ya, Kevin ya, tunggakan jaksa ya, tunggakan untuk penerimaan pajak bukan denda.
So yeah, so the answer is when the fine cannot be put to the subject earlier, process goes to, the alternate process is they will put a fine and in terms no, not a fine, and to like a tax, a burdening task for the subject that we was talking about, so that this person or under the law should pay the tax to fulfill their responsibility for the matter. So it's the alternate shape of the fine of that punishment, and is in the form of a tax that will be enforced to this subject, and the subject should pay this task, burdening task, so as an exchange for the punishment. So that's the alternate process, Mr. Hassan.
Thank you for the explanation.
Excuse me? Oh, thank you. Oh, thank you.
Okay, Mr. Hassan. Yeah. We can continue to the next presenter, or maybe any question for me. Okay. Okay. Six. Okay. Mrs. Ria Karina Lubis, please, for times for us.
Okay, thank you Ibu Ayumi. Good afternoon for all of us. Salam untuk kita semua. Saya langsung saja. Thank you for Mas Jonathan. Okay. Good afternoon, everyone. My presentation will be concerning the role of the International Law Commission in the United Nations. The emphasized condition about the progress or stagnant condition of the work, actually. So, whose work will be evaluated? The work of International Law Commission in the United Nations. And the International Law Commission henceforward will be called the Commission in this presentation. Okay. Next. Okay, thank you. Next. Since United Nations has been mentioned many times, I think it will be best for us if we talk about the structure of the organization itself, but of course in a brief way. As we commonly understood, the organization has 6 main organs. One of them is General Assembly. And the General Assembly has been assigned many duties, many functions and powers on them, such as discuss question about peace and security, and then give recommendation for the peaceful settlement, include promote human rights and promote international cooperation and development of international law. For the last function I have mentioned, the General Assembly has established the International Law Commission based on the Statute of ILC in 1947. If we see further of the statute, we will find the statute has assigned the Commission to do two main tasks. They are codification of international law and take care about the progressive development of international law. And in Article 15, the tax itself has each criteria fall in the tax. Yeah, to be fall under criteria of codification, the topic has been practiced in advanced manner by state, and doctrine and precedent has supported it. In the other hand, if the condition about the topic is the unregulated issue, and the rule has been practiced by state sufficiently, that two criteria will be fall under the context of progressive development of international law. Even the criteria is different, but the result is remain the same. Both of the tax will produce what we call draft article. So the Commission will produce the output of their work is draft article. In my writing, I call it draft article soon to be convention. If we already call it convention, we will relate to the topic of the sources of international law. We know convention will be the sources, the main sources of international law, the international convention or international treaties. Nothing wrong comes up from this task, but question has risen in the matter of the alteration of the output of the work. If the Commission usually produce draft article, it doesn't happen recently anymore. Can we go to the next slide, please? Okay. It doesn't happen in the recently. The Commission did not only produce draft article. That's bring me to these two approach. To answer the main question in my first slide of the presentation, does the ILC in progressive condition or stagnant? I already choose to approach to answer that question. The historical approach and teleological approach. I find this suit the question best. Historical will be elaborate periodically, start with the establishment of the Commission, the relation with the United Nations General Assembly, the remarkable convention they has produced, and the recent work of the Commission. In the other hand, teleology will be used to analyze the work of the Commission in the light of its purpose. What is exactly the purpose of the establishment of the Commission? That is the main question of teleological approach. I already explained about the establishment and General Assembly, so I think I should continue to the remarkable convention and the recent work of the Commission actually. The remarkable, I call it remarkable because the convention itself plays an important role in international law. The topics is about treaties, about international relations, and about the sea. Topic treaties, we already know about the Vienna Convention on Law of Treaties, and then in international relations, we always heard about Vienna Convention on diplomatic relations and other treaties related to this diplomatic issue, and of course various conventions on the law of the sea. All of the important conventions originate from the work of the Commission actually. So originate from the draft article from the Commission. Now let's move forward to the recent work of the Commission. By recent work, it means in the last 2 decades, in the last 20 years. In the last 20 years, the Commission has shown change or alteration in their final output of their work. The Commission did not only produce draft article, but mostly right now they produce draft principle, draft conclusion, and study report. The draft article soon to be convention, it will be part of the hard law, the legally binding instrument in international law. But different story with the draft principle, draft conclusion, and study report. 3 of them will be part of the soft, and we know soft law in international law is the non-legally binding instrument. So will this be problem for us in terms of development of international law? Turns out the result is even better. The result is even better. Draft principle, draft conclusion, and study report has been adopted by many states in their national law. And the good news is the soft law has been used by many international.
In the country, it is not.
Yeah. Okay. Has been used by international. Okay. Has been used by international tribunal and the international court as the basis for their judgment, for their verdict, for their decisions. So if we see the effect of the hard law and the soft law, I think what the Commission has been done in these last 20 years have the same effect with the hard law, the International Convention one. So if we going back to the main question of this writing, what happened with our development of international law? What happened with the ILC? Are they still progressive, or are they in the stagnant situation? The answer is, and in the same time will be my conclusion. Can we go to the next slide, Mas Jonathan? Yeah. The conclusion is the Commission leads the process of international law progressive development in their tendency to produce soft law and spread the influence on the source of international law. In the other words, if the source is progressive, then the international law itself is progressive. So the last sentence from me is the Commission in a good manner, in a progressive manner, and they do the good work regarding the progressive development of international law. That will be the end of my presentation. Thank you for the time and your attention, and I will be happy to discuss further if there's any question for me. Thank you.
Okay, thank you, Mrs. Karina. But before continue discussion, Mrs. Karina from what university? Tadi.
I haven't introduced myself ya.
Yeah.
I am Carlina Lubis from Universitas Tidar, Magelang.
Magelang, okay. Yeah. Please, Mr. Hasan. Question. Yeah.
Dear Mrs. Carlina Lubis,
Yes,
does
sir.
the codification, dear Mrs. Carlina Lubis, does the codification of international law material have to be followed the countries that are member of the United Nations? If it must be followed even taught in the country, is this not in accordance with the culture, which should be protected between the international codification of law or the law of the country inside? Mean mother.
May I answer the
Jadi
question?
maksud saya itu,
Okay.
apakah kodifikasi hukum internasional materinya itu harus diikuti oleh negara-negara yang menjadi anggota Perserikatan Bangsa-Bangsa? Jika harus diikuti, di dalam negaranya itu tidak sesuai dengan budaya, maka mana yang harus diutamakan?
Bukan budaya ya.
Ya, tidak sesuai dengan budaya, mana yang diutamakan antara kodifikasi internasional law itu atau hukum negaranya sendiri itu. Kalau bahasa Indonesianya, kalau bahasa Inggrisnya memang gurab-beladul saya itu.
Ya. Oke, Bu Ayuni, may I explain bahasa Indonesia? Boleh ya, Bu ya?
Ya.
Can I?
Ya.
Pak Hasan, terima kasih pertanyaannya. Saya coba ulangi untuk memastikan saya mendapatkan pemahaman yang sama atas pertanyaan Bapak. Apakah kodifikasi hukum internasional harus diikuti oleh negara anggota PBB? Itu pertanyaan pertama ya, Pak?
Ya.
Ya, yang kedua, jika perjanjian internasional itu tidak sesuai dengan budaya nasional, mana yang harus didahulukan? Kira-kira begitu ya?
Ya.
Oke, kalau bicara tentang kodifikasi, kalau kita bicara tentang perjanjian internasional, tidak akan jauh lari dari cerita tentang ratifikasi atau aksesi sebenarnya, Pak Hasan. Jadi ketika United Nations mengadakan International Conference untuk merumuskan perjanjian internasional, di situ negara-negara anggota akan menyampaikan niat mereka. Will they will they become the subject to the international treaties? Itu keputusan negara untuk memutuskan itu atau tidak. Seperti itu prinsip dasarnya. Kemudian ketika perjanjian internasional itu mereka tanda tangani atau mereka nyatakan terikat, tapi tidak sesuai dengan budaya nasional, maka kita akan menceburkan diri kembali pada pertarungan klasik hukum internasional dan hukum nasional. Pertarungan klasik. Namun saya kira ketika perjanjian internasional itu sudah disepakati oleh negara, mereka pasti sudah memperhitungkan mana yang sesuai dengan budaya nasional, mana yang tidak. Dan dalam perjanjian internasional kita masih mengenal apa yang namanya reservasi. Lagi pula ketika itu mau diratifikasi atau mau diaksesi, itu kan harus dibicarakan lebih lanjut dulu dengan legislatifnya masing-masing. Jadi prosesnya di situ, Pak Hasan. Jadi ketika proses itu semua sudah dilalui, saya kira tidak akan ada lagi benturan antara hukum internasional dan hukum nasional negara tersebut. Begitu Pak, kira-kira.
Ya, thank you, Mr. Karina Lopez, for the explanation.
Thank you. Thank you, sir. Back to you, Ibu Ayumi.
Yeah, thank you, Mrs. Karina, for the presentation. The next presenter, Mr. Muhammad Nur. Is ready?
Yeah. Okay. Please show. Okay. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Good afternoon, ladies and gentlemen. With all my respect, our moderator, Mrs. Aryuni. Thank you for giving me a chance to deliver my presentation this afternoon, and all participants of this conference. First, let us give thanks to Allah who has given grace and help for all of us, and we can assemble on this agenda this morning, this afternoon. My name is Muhammad Nur. I am lecturer of Faculty of Law, Universitas Ahmad Dahlan, Yogyakarta. Today I will presenting my paper about slavery of Indonesian migrant fishing vessel use, why and what to do. Okay, next please. Okay. Based on the report from the International Labour Organization, or ILO, commercial fishing is considered as a hazardous occupation with the world's highest accident and death rates. Because the shipping channel for fishing vessel is not like the shipping channel for commercial ships, because the fishing vessel shipping channel has to adjust the fishing area which frequently moves, and so that the working area will be very wide, even beyond the territorial boundaries of a country to the high seas. So ILO categorizes the nature of this work as dangerous, difficult, and dirty. It's dangerous because fishing far into the high seas with unpredictable weather condition with huge of risk. Then it is difficult because not everyone can work using various types of fishing gear, and not everyone is comfortable living in the sea for weeks or even months, and considered dirty because this job directly handles perishable fish. Okay, next. So a large number of fisheries units is influenced by the increasing trend of global fish consumption, where according to the data from the Food and Agriculture Organization, the average world demand for fish has increased by 3.2% per year. And the Food and Agriculture Organization also released the average global fish consumption at 20.5 kilogram per capita per year in 2018. The great demand for this fish then makes fisheries production continue to increase. The total world fishery production until 2080 is around about 20 million tons per year, and 52% of this production is still fulfilled from capture fisheries business. This reason then triggers the great demand for migrant vessel cruise abroad, especially from fishing vessels from owners in countries such as China, Korea, and Taiwan. So according to FAO, to meet the needs of migrant fishing vessel cruise in Asia, more than 70% of the crew members are recruited from South Asian countries, especially Indonesia, Myanmar, Cambodia, Laos, Philippines, and Vietnam. The increase in the recruitment of migrant fishing vessel crews then subsequently gone hand in hand with the increasing number of cases of violence, abuse, bad working condition, and slavery that we found. And it is why the protection for migrant fishing vessel crews is very important now. Next. Okay. At the international level, there are several international legal instruments that scope also regulates migrant fisheries crew members, including World Fishing Convention 2007, STCWF 1995, Seafarers Identity Documents Convention 2003, and others. But some of them not yet ratified by Indonesia. Next. Okay, I move to the result of my paper. My research of my paper found that various cases experienced by fishing vessel crews from Indonesia are caused by various weaknesses in the governance of the placement and protection of these workers both at home and abroad, starting from weaknesses in regulations, weaknesses in the phase before placement to post placement. There are weaknesses related to regulation governing migrant fishing vessels from Indonesia. Thoughts that profession as a fishing vessel crew is included in job that require special regulation in the form of a government regulation as mandated in Article 64 of Law Number 18 of 2017 concerning the protection of Indonesian migrant workers. But however, until now, this government regulation has not been issued by government of Indonesia.
Excuse me, Mr. Muhammad Nur, to save time, you can direct to conclusion. Ini time
okay,
is yeah.
Okay, sorry, Miss. Okay, move to the and next. Okay, no, okay. Yeah, so what should government stakeholders do to improve the protection system for migrant fishing vessel cruise from Indonesia. First, supervision system improvement. We need to improve the supervision system, and then second, improvement of data collection for migrant fishing vessel group, both in Indonesia and in abroad. And third, increasing the developing foreign cooperation, and fourth, increasing socio-economic integration programs, and last, ratification of the Working Fishing Convention 2007. Okay, I think that's all. I'm sorry, this is me. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Any question for Mr. Muhammad Nur about presentation about slavery of Indonesian migrant fishing vessel cruise? Why and what to do? Yeah, this is a new issue from Indonesia about modern slavery. Any question, please? You can. If there are no questions, we can continue to the next presenter, Mr. Suparto.
Yes, Dr. Aryuni.
Yeah.
But I'm still sorry because there is still a problem with my video.
Okay, you can present without PPT.
Yeah.
Yes.
Okay.
Yeah.
There is still PPT, but I can use my video only.
Yeah,
Okay.
yeah, video. Okay.
Okay, thank you. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, Bapak and Ibu. Thank you, Dr. Aryuni, and also Pak Jonathan for the chance and opportunity. First of all, my video tools doesn't work yet, so all of you cannot see my face, just only my voice. I'm so sorry for that, and thanks before for your understanding. This afternoon, I will present my article with title Overlapping Function and Authorities of the Maritime Security Agency, Bakamla, and the Sea and Coast Guard, SCG, in maintaining Indonesian maritime security. Okay, next slide, please. Okay, as an introduction, we know that Indonesia is an archipelago state with big areas of sea and land that need to secure from the crimes and problem, especially at the sea. And that will be doing by legal authorities. Next slide, please. So, based to this regulation, law number 32 of 2014 concerning maritime affairs, and law number 17 of 2008 concerning shipping, we know that there is two legal authorities. First, we call Bakamla, and the second we call Coast Guard. Actually, Bakamla is we already have now, but the Coast Guard is not yet anymore. Next slide, please. So, the problem is of this article is talking about the overlapping from both authorities. Even the Coast Guard is not yet already built by the government, but we see from the regulation itself. Okay, next slide, please. For a reason cause of the limitation of this presentation, so I will focus to the part that explain the overlapping itself. So one of the reasons for overlapping in the field is the existence of several duties and authorities between the Sea and Coast Guard and the same Bakamla, which are follows by the regulation itself. There is four aspects that I call as overlapping. First of all is about the authorities to supporting the implementation of life, search, and rescue. And the secondly is about the activities of guarding, supervising, preventing, and prosecuting law violations, as well as securing shipping and securing community and government activities in Indonesian waters. The third, there is the same activity to conducting hot pursuit, and the others is to stop and inspect a ship at sea. So it is the overlapping aspect from the Bakamla and also the sea and Coast Guard, especially about the same activity for search and rescue security activities. Next slide, please. So actually, the government are functioned and give an authority for both authorities only for the Maritime Security Agency, or we call Bakamla, which is we need Coast Guard as the real activity, just like in another countries. As a conclusion, next slide, please. Okay, as a closing conclusion, based to my short explanation, we can see there is an overlapping function and authorities. And as a question, we need to determine by revise the law. So there is a clear function and authorities between both of that authorities. So that's only my short presentation. Thank you for your attention. I'm back to you, Dr. Aryoni. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam
warahmatullahi wabarakatuh. Okay, thank you for Mr. Suparto.
Yes, ma'am.
Yes. The title of presentation is Overlapping Function and Authorities of the Maritime Security Agency, or Bakamla, and the Sea and Coast Guard in maintaining Indonesia's maritime security. Any question about this presentation, please? Okay, about Bakamla before Bakamla, it is Bakorkamla, yeah?
Yes, yes, ma'am.
Yeah?
Yes, ma'am.
And this is become issue for the enforcement law in the sea in Indonesia, because any agencies or institution that have jurisdiction right, yeah, Pak Suparto, yeah?
Yes, ma'am.
Yeah. But how the role,
yes,
the main role Bakamla in Indonesia, if there is effective.
Based to my opinion, we still don't have actually our Coast Guard, just like another countries. So until now, we just still have a Bakamla only. So we cannot say that it is effective or not, because we have only one institution to keep our sea and the problem itself as a nation. That's my answer, Dr. Aryoni.
Okay, thank you.
You're
Mr.
welcome.
Suparto. Yeah.
Yes.
All right. This the last presenter, Mrs. Linda, but she's not attend in the room, so we can to closing the session. All right, ladies and gentlemen. So by the end of presentation from Mr. Suparto, the session now is safe to conclude. Congrats for all participants to successfully presenting the ideas of papers. Give round applause to everyone in this room. Now the session is finished. Please on your video, we will take a picture yang ada yang on videonya ya, bisa.
For everyone, if you please open up the camera if you can, so we can take a picture, all of us together. Okay. Ya. Silakan Ibu.
Okay, yeah. Yeah. As a symbolic gesture to appreciate and acknowledge all the presenters, author, and co-author, we would like to show all the certificates entitled to all of them. First, for Mr. Maskun, please, Jonathan. Yeah, as symbolic, yeah, Mr. Maskun. And second, for Pak Hasmi is still here. Okay. Yeah. Okay. Tomorrow, if you will join again or to interactive in parallel session, please you can join in main room and the code room in parallel session 2. I'm on behalf of the committee would like to apologize if there is any inconvenience. Thank you. Assalamualaikum warahmatullahi wabarakatuh. Yeah, this is finished. You can leave and the session is finished. Yeah, thank you.
Thank you so much all the participants.
Thank you, Mrs. Aryani.
Ya, terima kasih.
Terima kasih. Thank you. Assalamualaikum.
Waalaikumsalam.
Oh iya. Pak Hasmi?
Ya.
Jika masih berkenan, besok bisa join lagi.
Insyaallah, insyaallah.
Oke, thank you. Leave aja.
Yeah, thank you.
Ini juga
Leave meeting ya. Leave meeting aja deh.
So welcome back to the main room of this meeting. So welcome back to the main room of this meeting. For you who has ended the parallel session 1, thank you. So today the day 1 parallel session 1 has already ended, and for you who wants to join parallel session 2 for tomorrow, we will start at 8 a.m. sharp tomorrow for parallel session 2. So that's all. Thank you. You can leave the meeting room. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.